Hi everyone. Welcome to the Comparative Law series. My name is Simon Sun. I'm an institute candidate at Maurer School of Law at Indiana University, a member of the Graduate Colloquium, and one of the co-founders of Law Science. It is lovely to see you here. In this series, we invite experts from around the world to talk about comparative law as a methodology. The event is a collaboration between the Graduate Colloquium from Indiana University, Maurer School of Law, and Law Science. On behalf of Eka Putra, as the coordinator of the Graduate Colloquium, I would like to introduce the mission of the Colloquium. The Graduate Colloquium is a biweekly online meeting for graduate students at Maurer School of Law to discuss common academic concerns and research interests. Law Science is an academic initiative created by Faris Al-Malki and me. We aim to promote the study of law by bringing diverse methodological perspectives on the different issues of law. If you're interested in more law science events, please join our email list by clicking the link we have shared in the chat box. In this session, the event will be led by Faris Al-Malki. Faris will be moderating the presentation and discussion by Professor Mary Louise Harris from University College Dublin. Without further ado, here's Faris.
Thank you, Simon. I'm Faris Al-Malki, co-founder of Law Science and the illustrated candidate at Maurer School of Law. Today, I have the great honor and pleasure to introduce Professor Mary Louise Harris, the Associate Professor at University College of Dublin and the Director of the UCD Center of Human Rights, as the speaker today for the series of comparative law. During the pandemic, Professor Harris initiated an online series called Human Rights Conversation in Times of COVID-19, discussing the legal impact of the COVID-19 on people's freedoms. She directed the French law program, which aims at training Irish students to the French civil law system. She is currently the principal investigator on the research project entitled Democracy in Crisis, Exploring the Citizen Challenge of Deliberative Democracy in light of the French and Irish constitutional experiments. Professor Harris obtained her PhD degree for her dissertation, The Implementation of the European Convention on Human Rights by the United Kingdom, and 2 master's degrees from University of Pantheon, Essex. Professor Harris' main academic interests are comparative constitutional law, legal education, European public law, and European human rights law. She has published several articles and book chapters about legal education and legal methodologies, comparative constitutional law, and French constitutional law. Today, Professor Harris will be talking about methods for constitutional comparative law. And during her speech, we welcome you to add your question in the Q&A box, and I will be happy to moderate and ask the question. Without further delay, I welcome Professor Mary Louise Harris.
Thank you very much, Faris and Simon. I'm really happy to be with you today, and I'm extremely grateful for the invitation. I also thank all those involved in the Law Science Initiative, and I thank also those involved in the Graduate Colloquium at the Maurer School of Law of Indiana University. In particular Eka Putra and Professor Goodwin, who I understand are in the organization of the colloquium. So I will share the screen now to give you a few slides. Okay, sorry about that. It should be in okay. So I would like to mention, So I would like to mention 2 points about the title of my talk first. It's very close to the title of the Dixon piece that I will refer to in a moment. But I didn't want to use the same title, obviously. So, but I will talk about the same kind of issues that she talks in her paper. And then second point, at the end of the talk, you probably won't have an answer, a definitive answer about this question, and we will see why. Okay, so in terms of outline of the talk, I would like to, I will divide the talk into the following parts. I will first make a number of general observations about the legal comparison. So these observations apply in comparative law in general, but I will make it more in the context of an inquiry in comparative constitutional law. And in this part, I will talk about the modes of comparison developed by Tushnet and in his seminal piece, The Possibilities of Comparative Constitutional Law, and also as they are revisited by Dixon in the reference I will give you in a moment. Bearing in mind that Tushnet in his piece, he places his study in the realm of constitutional making and constitutional interpretation of the US Constitution. So it's very much about judges, and he uses extensively US case law to see the different approaches in comparative constitutional law. So today I'll talk more about the approach for a student in comparative constitutional law, not necessarily for the constitution maker or the constitutional judge. And there are really many reasons to refer to these two authors, Tushnet and Dixon. Because Tushnet is a pioneer of comparative constitutional law, because he actually contributed very much to the methodology in the field. And as Dixon puts it, he has provided a useful taxonomy of comparative modes. He has used a mixture of different comparative methods and ultimately defended a realistic approach to comparison, which makes it possible for others, like me, to follow in his footsteps and continue building a field that is already a powerful source of legal and political inspiration. So note the word, they use the word a lot, mode or approach, not necessarily method, but they actually use it sometimes interchangeably. And Dixon has elaborated on that, on this taxonomy, and she has refined the taxonomy, which is very useful because she takes a stance which is more, it's a bit broader than just, the constitutional judge. And I would like also to mention the pioneering work, certainly in France, where I'm originally from, of Professor Elisabeth Zoller, who has worked and published extensively on comparative constitutional law and especially on American law. And she has been a very good source for French scholars, French students, about knowing the American system. I know she's a member of your faculty, so I would like to acknowledge a very significant work in this field. So you will see, and I go back to the previous slide, so you will see that the two pieces I'm going to refer to, but also other works that I've used for this talk today. And obviously there are many others, so it's not an exhaustive list, obviously. But there are, so I have a mix of, American and continental, European work here. So secondly, and this is the second part of the talk, I will develop the different steps of the constitutional comparative inquiry in constitutional law. And thirdly, if time allows, I will talk about two projects I did in comparative constitutional law recently. One is about a research project on a comparative issue. It's about the war powers of the president under US and French law. And the other project is about a teaching project that you mentioned, Faris. I conducted the project online with first-year law students. And in this third part, rather than talking extensively about the projects, I would like to interact with the audience and to ask questions about how you will actually deal, you would deal with the topics. So if we start with the general observations, about legal comparison, the first thing to say is that there is an absence of a single method of comparison, okay? So, and this is a valid observation for comparative law in general, as well as comparative constitutional law. And just one note here, the trajectories of the two fields, comparative law and comparative constitutional law, are quite distinct, as you know. I mean, comparative law has developed primarily focused on private law, okay? And as you know, we can trace the establishment of comparative law at the end, around the end of the 19th century. And then you have the development of what we call constitutionalism worldwide, which has developed by waves. The first wave being the French and American revolutions, and then you have in the 20th century you have the waves of decolonization in Asia and Africa with the writing of a lot of constitutions, and then back to Europe in the late 80s with the fall of the Berlin Wall. You have, you know, a lot of constitutions emerging. So I'm not elaborating on this. I'm sure you know about the history of comparative law and constitutionalism, but just this to say, this is to say that for a long time, even though these fields were developing, there was not really a reflection on the method. Okay, and this is the same for comparative law. Obviously, this has changed now, and there is a lot of reflection which is going on about the method, and at such a point that now in comparative law you have books about methods of comparative law. Okay, so, and it has been revived by the phenomena of globalization, and in the European context by the phenomenon of Europeanization of law. So, which has helped to find a method precisely. And you have even journals have been established to talk about the method. If you think about the Journal of Comparative Law, which has been created in 2006, it indicates in its first editorial that in order to understand the globalization of law, a strong emphasis will be put on the comparative legal method. So that's an important point. But there is no single method, rather there is a plurality of approaches, as we will see. And this is why I say on the slide that everybody now is doing comparative law. It's almost a given, especially in Europe, where if you do a PhD, necessarily you have, you know, to compare with another legal system. But everybody is doing it, but without an agreed standard on how to do it. Okay, so that's a bit paradoxical. Now, another observation, and these observations relate really to the exercise of the legal comparison. It's a work of interpretation, okay, because comparative law, as you know, does not produce any legal norms, and comparative law does not equate either to the regurgitation of the rules or the norms of the foreign system. So what does it do? What does it produce? Well, it produces different readings or interpretations of the law. In that sense, it's a work of interpretation. And as you know, interpretation involves kind of two intellectual operations. First, you have to assess if you need to interpret. So if the norm, your own, and then the other foreign system, if it is vague or obscure, if you need to interpret it. And then you have to choose, to make a choice. And to choose how to read it, what is the preferred meaning, because so the result of interpretation is the production of a norm, because a norm can only exist if you give meaning to it. So in the context of a comparison in comparative constitutional law, you must be able to interpret your own constitutional system, which I know maybe in the US it's quite difficult sometimes because there are a lot of disagreements. But you have to also be able to interpret the foreign legal system. And in fact, to deconstruct the foreign legal system, if you can, to get rid of all the preconceptions that you have. And this is where actually the position of the comparatist is important, depending on whether the comparatist is a judge or a scholar or student. Because as it is explained, in Pontoro, for example, the judge will try to find the authentic interpretation because he has to, or she has to pragmatically put an end to the legal dispute which is before him. But the scholars, they are not really concerned with the finding of a single truthful meaning, even if some scholars, they will actually take a stance. But they are more concerned about exposing the different meanings of a constitutional text or norm or institution, what we call a scholarly or doctrinal interpretation. And at this stage also, you have to make the distinction between a comparatist, if you do a real comparative work, or if you're just an expert in a foreign legal system. Okay, so there is this nuance. And by the way, even the word comparatist is not agreed on, because you can say apparently in English comparatist and comparativist. It's not my first language, so I don't have any opinion on that, but apparently there are the two expressions that you can use. So yeah, the work of the comparatist aims at offering another perspective, another interpretation on your own legal system by comparing with another one, with a foreign one. But the aim of the expert in a foreign law is more maybe modest, because he aims at studying the foreign legal system for its own merit and to transmit the knowledge and the information about this foreign legal system. So it's not quite the work of a comparatist. Okay, so me implying that the work of a comparatist is a bit more difficult and challenging. So, well, the work, this work of interpretation in the context of comparative constitutional law, it brings with it its own issues, the issue of bias, etc. So this is my next point. Legal comparison is inherently a subjective work. So the other observation I will make is that obviously you have to be careful to keep some distance, some objectivity, to detach yourself from your previous knowledge of the other legal system, and to resist the bias of your own legal culture, which is difficult to do, but it's kind of, yeah, you have to be open-minded. I was once told that the common law system was the best in the world, and the person who told me that was a judge in the Irish Supreme Court, and he didn't know I was French and from the civil law system, and I say sure, that's that's right. So there is a danger in that, in comparative law, to be biased, but also the biggest danger is obviously to rank the legal systems. And there has been a controversy some years ago about the World Bank ranking the different legal systems in the Doing Business report, saying that the civil law systems were actually very difficult if you wanted to set up a business, where the common law system were much more flexible because there was less admin, etc. So that's a bit, you know, even if it's true, that's a bit problematic, because, you know, legal systems are precisely the product of a culture. Anyway, so it's difficult to do, especially, by the way, from countries which have or had a strong influence in the world. You know, thinking about the US, obviously, but about France as well, with the civil law system. They are sometimes the scholars are very surprised not to find the same things abroad, think that, you know, everybody else will actually do the same kind of things. Now, the other observation is about the epistemological dimension of comparative law. So as you know, epistemology refers to the theory of knowledge, how you structure, how you approach knowledge. So really it's about the method, the scope, the validity of the theory. So you must, in a comparative inquiry, you must define the object, that is the topic to be discussed, and the foreign law you will compare with, and how you will do that. And this is where we come back to the absence of a single method, but the fact that there is a plurality of methods. And this is where taxonomies are kind of, you know, this tripartite taxonomy of Tushnet is very useful, because you need that to be able to start, to have a starting point, you know, to approach a subject. So here I will do a little bit of, you know, develop a little bit their approaches. So when you see an asterisk on the slide, it means that there is another slide which explains, okay. So Tushnet talks about, and I'm sure you are familiar with this, functionalism, expressivism, and bricolage. And then, so I put this, you know, classification or categorization, as well as Dixon's, and then you can reflect on your own, on how you approach things, how you have approached your different work in your different works the comparative law exercise. So functionalism, it relates to the idea that political institutions, and so the institutions you find in the Constitution, they perform certain tasks which are common to all systems of governance. And we talk about functionalism as well in comparative law in general. So the task here is to identify these common functions, and then to consider the similarities and differences. And, you know, the comparative uses this approach really to identify the commonalities, similarities, sorry, but the end, you know, goal is to see if they can borrow, okay, if they can borrow some institutions and if it's better in the other legal system, etc. So, for example, you can compare and you can identify the Constitutional Court as being, you know, a relevant topic of study because they perform judicial review, because they protect rights, etc. So, by the way, constitutional courts have become a whole field in comparative constitutional law. There are so many studies about constitutional courts, especially in Europe, and to see, or Supreme Courts, because some countries, they don't have constitutional courts, but Supreme Courts. So it's interesting to see how they perform judicial review, how they protect rights, etc. Okay, so that's typically an object about an institution. You can also, for example, think about the central banks. Central banks, they are not, you know, an institution which are in the Constitution generally, but they provide important insights for the about the constitutional regime, because they actually they provide the financial banking services for the government, and they also, this is how the government implement the monetary policy, and they issue currency. So that could be an interesting study in comparative constitutional law and other aspects of banking law. So the aim is borrowing to improve the way in which certain constitutional arrangements of your own system operate domestically. So the thing is that with this functionalist approach, and this is what Tushnet says, you have to find a middle ground. You have to be not too general, because otherwise the comparison is really banal, or not too specific, because then you know, it's not to be so to be unique, because otherwise it makes the comparison very difficult. So it's you have to have an intuition that the institution is actually performing the same function. And then you have expressivism. So I understand that expressivism relates to the idea of that constitutions tell stories about the culture of a particular nation. So because the constitution emerges out of the history, I mean the nation's history, and it expresses a distinctive character, national character. And this is where in his piece he famously refers to the Irish Constitution, and he refers to the 1937 Irish Constitution for two aspects. For the doctrine of unenumerated rights, the fact that the rights that are enumerated in the Irish Constitution, then the constitutional judge can add to that by finding or discovering the rights that would be constitutionally protected. And also because of the references in the Constitution to the Catholic Church, to religion. So he develops a bit about that. So the problem with expressivism, and that is really interesting in the piece, is that how can you justify to resort to other constitutional experiences if you view that your constitution is unique? I mean, it's distinct, because it means that you don't want to, or you can't really learn from elsewhere, because, you know, your constitution is distinct and the other constitution is also distinct. But one interesting answer that Tushnet makes is that he says looking elsewhere may favor changes. He says that the strength of expressivism lies in its ability to allow us to engage in a discussion of what our constitutional character is, rather than limiting us to take it for granted. Okay, so the fact that you look elsewhere is a good sign. And then there is a very interesting idea of bricolage. Yeah, it's interesting that he started the explanation of bricolage by referring to Claude Lévi-Strauss, who is the French anthropologist, who talked about bricolage, you know, in his work about primitive societies. I understand it's a French word, but I mean, you know, I suppose it describes, it's DIY, if you want. The literal translation would be that. It's a very specific activity which refers to bricoler. And it's a good, Tachnet makes a good metaphor or a good contrast, because he contrasts bricolage with the bricoleur, with the engineer. The engineer has scientific knowledge and he has a method, or at least a plan, okay? He knows what to look for and where, okay? But the bricoleur, by contrast, is learned by doing. So he takes whatever it is at hand and he fixes the things, and provided it works, it's okay. So by definition, in a way, bricolage is no method, okay? And this is, I think, where the argument of Tachnet is a bit weaker, in a sense, when it comes to transposing the idea of Lévi-Strauss bricolage to comparative constitutional law. I'm not saying it's not possible, but it takes only the example of the US, of the drafting of the US Constitution. So this historical example to say how the Constitution was drafted, and the fact that the Constitution was actually a compromise between a well-designed approach. They wanted, you know, for the broad themes, they kind of agreed, but for the details, it was more bricolage. So it was more, you know, picking, you know, things and compromising with the different people involved in the drafting. So maybe, you know, bricolage is a concept which might deserve some better explanation or a better approach, okay, because it's a bit, it's vague. I would say that another example of bricolage would be, and I mentioned when we talked before, the Civil Code by Napoleon, because that's typical of a very good work of compromise precisely. The Civil Code was written in very few months, very quickly. It was supervised by Napoleon, and only 4 lawyers were involved, 2 from the south of France, influenced by Roman law, and 2 from the north, one from Paris, the other from Brittany, so were influenced by customary law. And that was to unify the country legally, I mean, the legal systems, okay? And so they had actually a plan, and everything is very well conceptually organized in the code. This is why it's unique in a sense, okay? Because in the meantime, France had only 1 civil code, but 15 constitutions since the revolution. So the civil code is in a way, is really actually the constitution of France, I would say. But so that was a kind of example of bricolage. But yeah, again, I'm not going to elaborate too much on that, but this was done in very quickly because they relied on the old regime works, because a lot of what's done had been done before. Okay, so it's not a miracle, in other words. Now, so I've put as well the equivalent, or like, you know, what Dixon presents in our own taxonomy, and you can see that we go back to this functional comparison, which is very empirical, because you need to look at how things work in the other system, and expressive or reflective comparison. It's which is the equivalent to looking into the mirror, so to reflecting on your own system. So what is helpful with the Dixon taxonomy is that it depends on what kind of constitutional aspect you compare. So I would say that if you use this one, you look at what is in brackets. If you talk about the constitutional text or structures or doctrines, you might, you know, think about, you know, all these ideas of migration of ideas, etc. If you talk more about values, okay, notably commitments to human rights, equality, dignity, democracy, rule of law, you have this kind of movement, which is called, or this approach, which is moral cosmopolitan comparison, which is something that you look at, you know, a big number of systems in the world, and you try to find similarities in how they protect rights, how they, it applies to these areas and less in others. But this is just, at the end of the day, it's just labeling. It's a question of label. And this is, it might not be visible in your work, but you can make a reference in your work. When you do comparative constitutional law, you can make reference to these authors and saying, I approach, you know, my comparative study according to this, you know, to this mode, etc. But it this is something that you can do. There is also the I'm not referring to the universalist and pluralist or relativist approaches, but that's another possibility. But they are they can be combined. Now, to come back to to the last observation, what you have to understand in comparative constitutional law is that a legal comparison is you have to build it. It's a handmade work. It depends on the issue that you deal with, okay? And it depends itself on the goal of the comparatist. So legal comparison depends on the question you deal with, which in turn depends on your goal. In other words, strategy is dictated by your goals, or the goals lead to strategies, if you want. This is why in the work of Duschnetz, if you know, it takes there is too much emphasis on the judge. But what about if you're a scholar, a practitioner, a student? It's not the same, okay? So it will dictate a different method. So because all this implies choices, this is how I will talk about the other bit of my talk. First, you have to contextualize, you have to choose your case study, and you have to justify. And these three kind of steps, they can be combined. They're not sequential, but this is the things that you have to do when you do your comparative inquiry in constitutional law. And this is actually what can appear in your work. You have to explain all this, okay? So, and this is actually adapted from Pontoro, the reference I put at the beginning. Although in my chapter on justifying choices, I've put differently, but I've drawn from her three parts. So when you contextualize, okay, you have to ask yourself a certain number of questions and to do certain things. You have to be aware of three kind of, you have to get to know the other legal systems, okay? And you have to be aware of three degrees or three steps of knowledgeability. First, the linguistic knowledge, because it's always better to read primary sources in the language, okay? Although it's not always possible. What I call the operational knowledge, that is to really understand how the institution or the constitutional text or norm that you study operates in practice in the other legal system. And cultural knowledge, indeed. And what about cultural knowledge? And this is where we come to the notions of thick or thin comparison and interdisciplinarity. Is it just about legal culture or is it broader? Encompassing, for example, political culture, which is easy enough to do if you're a constitutionalist, okay? Is it about historical culture? Again, it's easy enough to do when you're a constitutionalist because you know a lot about history. But what about economy? What about the whole, the societal or, the knowledge of the society? Because all the time you spend on the foreign system, you don't spend it on your legal system. So if you have time constraints, you can't really do it all. So, and there is a good image here, a good metaphor again. The legal culture could be the tip of the iceberg. So the legal text, norms, concepts, institutions. And then the hidden part, which is called in French the mute part, relates to the non-legal elements of the culture. And it can be infinite, it can be broad. So you have to set limits to your study. Okay, so that's why I say, there are choices to make. So you have to define an area of relevance okay, about the foreign legal system, about the variables and elements to study in the foreign law. And this is what I think Dixon was referring to when she talks about thick or thin comparison. Okay, it depends on, you know, what you include in your comparison. Yeah, another point about law and foreign law, and this is why, what is law? That's another problem, okay? And it's often, you know, law is moving. It's a, you know, there is not the same understanding in different systems, in different cultures, etc. So this is a slide I use when I teach comparative law in general. So it's not necessarily relevant. I mean, it's not necessarily just for comparative constitutional law, but if you study a constitution, obviously you study the text, the constitutional conventions, you can study obviously constitutional case law, but not necessarily private regulation. But all these things are, you know, part of the legal culture. And for example, a good example would be for the French Constitution. The French Constitution, if you study rights, the protection of rights, well, you won't find anything in the French Constitution concerning rights. Okay, so there is no catalogue of rights in the French Constitution. So you would be a bit surprised, like, you know, in the Irish Constitution, there is a catalogue of rights. Not in the French. In the French, you have texts attached to the Constitution which deal with rights, but it's not in the text itself. Okay, so you have to know where to look. So that's a question about law. And then a question that the students really ask a lot when they undertake a work in comparative constitutional law or comparative law is how many countries, how many legal systems are they kind of close, or like, you know. So this question of the case studies or comparators, it begs the question of comparability, yeah, in the first place, and then maybe the issue of legal families, although it's not so relevant in comparative constitutional law. About the question of comparability, how do you recognize that two legal systems, institutions or norms or concepts are comparable? What degree of similarities do you need to make a comparison? So again, there is no definite answer to that. It relates again to your goal, to your background. If you have, you know, a knowledge of the other legal system and intuitively you know that this legal system could be compared with your domestic legal system or the one you were trained in. So that's an important question. And generally, I advise students, including PhD students who have more time to do their comparative inquiry, to limit themselves to maybe 2 or 3 legal systems, because all the big studies where you have, for example, the 27 EU countries, generally it's done by a team. You can't really do that on your own, okay? So again, it's a question of who is making the inquiry. And then the question of legal families, and that was the sense of my question to Professor Reitz last time, because I asked a question about the legal families, if it's still relevant. It's not necessarily relevant in constitutional law, okay? If, for example, you have a topic in constitutional review again, with reference to Irish and French law, you will realize that there are a lot of similarities, because more similarities between Irish and French law than Irish and UK and British law, because they both have written constitution, republican constitution, with similar ways of doing constitutional review. Okay, so this distinction between common law and civil law is not relevant. But again, you have to be aware of, and this is the next slides I wanted to show you, because I found the last talk really interesting about that, because Professor Reitz has an extensive knowledge about multiple legal systems, is that even in this area, there is an evolution. So we have the traditional legal families, common law and civil law, as you see on the screen, the red common law and the blue civil law, and other types of families, okay, the mixed system, mixed jurisdictions that we call, but that's a really old-fashioned way of, you know, approaching things. It's still valid for some parts, but, and now, for example, there is an interesting study which was done by Matthias Sims, another taxonomy, where, for example, taking the example of the states, where you see it's in the common law here, but then it's another color in this one. And he and this is a study which is possible now because they use variance, the coding of laws. So they have put different, you know, indices or elements, and they code the laws about rule of law, democracy, systems of government, protection of whatever. And then they have this, you know, taxonomy. And you see that the states, they are a mixed legal system. They're not really common law, they are mixed legal systems. And Australia, the position of Australia is, you know, closer to Europe. So you see, it's something you have to be aware of when you do your work, that there can be differences, different approaches now. Now, sorry, to come back to the other part about justifying the comparison, that the last element, coming back to this idea of the absence of a single method. It can be a problem for you as a comparatist because it can cast doubt on the validity of your work, okay? And I would like to come back to a point made by Dixon in her piece. She says, like Tushnet, many leading comparative constitutional scholars, they treat the questions of method as implicit rather than explicit in their work, and they do not engage in extensive debate or justification of the topic. Well, it's okay, but I think you still have to justify and explain what you're doing as far as possible. And this is what she says, actually, when she adds in her conclusion. She mentions, and she mentions it as regards scholars. She says, we need to articulate a method for the audience of your work. It can be supervisors, PhD examiners, and most of the time, and that's very true in Europe, funding bodies. You need to explain why you are doing what you do. And the only benchmark possible to test the validity of your comparative work is actually what I call, like in science, but the protocol that you have established for your comparison, addressing these W questions. Why? What do you compare? How do you compare? And why do you compare? Okay, and you have sub questions about why these two jurisdictions, why do only a descriptive approach, not a normative approach, etc. So this is what Dixon calls the key methodological questions that you need to ask. And some French scholars, they label that as a scientific approach, actually. Obviously, it's a bit of a misnomer because it's never a scientific in the sense of hard science, okay? Because you have to make choices, you have to interpret, you have your bias, etc. But make sure actually to make this justification visible in your comparative work. I mean, a rational explanation of what you are doing, how you are doing it, because there is a line between the work which is purely objective, which is not possible in law. It's not possible to do. And a work that is the result of your intuition, that is the result of your imagination, what you think the other system means, okay? It's a bit lazy to do that. So in other words, you are not scientists. We're trying to convince through demonstration, validation, repetition of the experiment. You're not activists either, because you don't try to convince through emotions. And you're lawyers, so you will convince your audience by argumentation. And this is exactly what it is. You know, in your comparative inquiry, you have to make your case about the comparison, okay? So that's actually, these three things are the things you need to develop in a methodology chapter. So we often recommend to the students, I mean, you do that too, to do a methodological chapter, whether it's embedded in the introduction or whether it's standalone chapter where you explain all your different choices. And generally, obviously, the students will choose a legal system that they are familiar with because of their background, their personal background, but that's not really acceptable. Sometimes you have to explain why there is a relevance to your comparison, even if we understand that obviously you have better access to the sources. But so it's something which is very difficult, because in this work you are very free. You have academic freedom. I mean, you have infinite freedom, but also the justification exercise will allow you to limit this comparison. So it's your choice. And then, so the last, sorry, yeah, the last bit of the talk, I have no idea how much time I've left. Yeah, okay. So the last bit of the talk is actually something I wanted to be maybe more interactive, and to refer to experiments or activities I've done in the past few months. So the first was about a topic I decided to research on, about the war powers of the president under the commander-in-chief clause under US and French law. And the first trigger, what triggered me to do that is that I thought that these presidents were very powerful. They had a lot of power, and the French president is actually really powerful. He can decide in 1 hour to send troops abroad. It's done in 1 hour. There is no control, no scrutiny by parliament, nothing. So it's a very wide power, okay? And that's an interesting project because, it's a constitutional law project, obviously. So my question to you, and I'm not asking you to deal with that, but what kind of difficulties do you think will arise with such project? And what level of thickness do you think the comparison will need, okay? Do you think it's a relevant comparison to make, in other words? And the other project was a teaching project. So I was asked by the dean to teach a core law module to law students in first year. So they didn't have any law background. They were very young. They are very young. They are like around 17, because it's an undergrad degree in Ireland, in Europe, and it was online because it was during the pandemic. So they were first year. They have never been to university except online. So I decided to ask them to write samples provisions of a constitution of an imaginary country. And I gave them very specific instructions. So only a sample of provisions of the preamble, of the form of the state, okay? Institutions, but only one or two. They could talk about the parliament or the president or both, that's it. And fundamental rights. And they could talk about certain fundamental rights, that's it. And then I provided them with the English version of the Irish, well, obviously, yeah, the Irish Constitution and the French Constitution that they had to read. And then I asked them to find a third one to compare with. And they were free to choose. Most of them chose the German one, but also some of them, they chose the US one. Another group chose the Swedish Constitution. And then they actually invented the flag, the anthem. So the project was a success. They were really good, and they presented it orally, and that was quite a success. But I would ask you, how would you go about research on such a project if you were, to write a constitution? So that's my two questions. If you have other questions about the talk or about this project. So I thank you very much. Before I finish, these are the steps, and I will leave the slides with you, but these are the steps I actually put in my chapter that I refer at the beginning. These are the steps of the research, which are more detailed, and I mix the intellectual steps with the pragmatic steps, practical steps for the doing a comparison. So these are the two slides, but that's it for me. So thank you very much, and you can see the different flags done by the students in their project. Thanks very much.
Thank you, Professor Paris. That was an interesting and insightful speech. Before going to the question and answers, I would like to introduce Professor Goodwin. Professor Goodwin.
Thank you, Paris. Thank you so much, Professor Paris. This has really been fascinating, and we're, on behalf of Indiana Law, we are just thrilled to have you today.
Thank you very much. Thanks. That's great.
I was personally very excited when you said that everyone's doing comparative law, but no one knows what method they're using. That really, for me, has been trying to explain this to students as well, has been kind of the sticking point. Is there does not seem to be one particular method to go about this, and even describing what doing comparative law is tough.
Yeah, I think there is a helpful article as well by Van Uck, which I don't know if you, the different methods, and he is very actually accurate in all, because he, not only functionalism and expressivism, I don't think he used expressivism, but he refers to the historical law in context. So there are other labels, but at least it's very clear about what it involves. And what I tell the students is just to say, to use these authors to label their research, and that's it. That's a method. And apart from that, I don't know what we can do.
I agree with you. And I think that Van Hook article I gave to students last semester to look at. So that's perfect. I also noticed, I joined a little bit late. I don't know if you mentioned this, but one of your sources was Elizabeth Zoller, who is a visiting professor here at Indiana. So we're always very happy when she arrives on campus. So
I know I indeed mentioned her because she was actually a very influential colleague. I mean, a prof, because I was a student at the time, and she was really instrumental in making US law known to French students. Okay, without her work, it was very difficult to access because I'm really old, so there was not so many. The difficulty today is really to select the sources, but in my time it was more to find the sources because there was no not all these facilities on the internet, etc.
Right.
So yeah, her work is really important, and it's really recognized in France. I mean, she's one of the most prominent scholars in comparative constitutional law in France. So
yeah. Wonderful. Well, I know that there will be other questions, so I don't want to take up any more time, but thank you so much. Very nice to meet you, and we're so happy to have you.
Thanks very much. I appreciate it. Thanks.
So I personally have two questions, actually. One of them is more related to the constitutional comparative law, and one of them is in general to the comparative law. So I will start with the general one. To what extent do you think that comparative law has been used in harmonization, either regional harmonization or international legal harmonization?
Then I would know more about the regional one, okay? I'm not an expert in international law, so I can address that in the context of the harmonization in EU law or harmonization in ECHR, European law, because we have the two legal systems, two European legal systems. They have very different aims, okay? So in the EU, it's a declared goal, it's approximation, what we call approximation. They want to actually harmonize in that sense that they really want to have the same legislation for, the 27. So there has been really a big push in, finding some, as common policy, etc. So necessarily that implies, harmonization and the use of comparative law, because you compare the different legislation, you see how it can work, etc. In European law, in the sense of the system of the European Convention on Human Rights, which produces the European law, not EU law, but European law, it's interesting to see that there is, there has been a lot of comparative law, and if you read the cases of the Strasbourg court, you see that there is often, if not always now, a comparative law part. So for example, if you read the case about abortion against Ireland, so this ABC case against Ireland in 2010, I think, there is a comparative section about the different legislation on abortion in the different countries. And in the ECHR system, it's 47. Okay, so it's a big system. And then it's interesting to see that they set up a division of comparative research in Strasbourg, in the Strasbourg court, because they needed precisely to do more comparative research. It doesn't mean that there is a work towards harmonization, though, because it's not the job of the Strasbourg court to harmonize. Okay, it's to find a consensus. It's to find a consensus, but even if they find a consensus, it doesn't mean that the particular country which the case is about is going to be imposed this consensus. And I'm again talking about this case about abortion, because obviously in Europe there is a consensus about the fact that a lot of countries allow abortion, most of them, except Ireland, which has a very tight legislation. I used to have a very tight legislation, and even they found a consensus, but they let, I mean, they found a violation for a certain aspect, but they said, even if there is a consensus, that's not our job to say to Ireland, you need to harmonize your legislation, because they leave a margin of appreciation to the country. So it's quite a complex problem, but certainly, yes, comparative law is widely used in the background work. Yeah.
Thank you. I have a question from, if I'm correct, Ho-Won Kim. She asked about the bricolage system, and she is saying, actually, she just sent a revision to her question. So I think her question is saying that, do you think that's culture in general, and when it's related to legal culture, have the same order? And would it be possible to have the same cultural order in a constitutional law? If I understand the question correctly.
Yeah, I have the question now. Maybe you see that on the screen, sorry. Yeah, I'm not sure to understand the question. If you can, it's about because I was starting to read the question and then it's disappeared. So I don't know if you can repeat the question.
Yeah, you could go to the answered. So in the Q&A box, there is answered questions, 3 answered questions. There is open, answered.
Oh yeah, sorry. Mm-hmm. Yeah. Yeah, well, okay, so this is a reference to the work by Lévi-Strauss, but Lévi-Strauss was in a completely different field, and he was the expert in structuralism. So precisely because he was studying cultures which were so remote to ours, you know, they were primitive societies. So he was trying to kind of, typically French probably, but to try to find some kind of order or structure in these in these societies. And I did some, I taught at some point some legal theory with students, and we actually studied Lévi-Strauss. He was opposing, how do you say in English, the cooked and the non-cooked food, for example, or you know, all the symbols of these societies. And his goal was really to find a system, if there was a system, you know, that could be discovered in those cultures. But I think it's difficult to it's easier, you know, to find in a constitution when you study constitution, because necessarily in a constitution it's already a conscious work, whereas, you know, Lévi-Strauss is referring to something, the culture is something which is not conscious, you know, it's not, you know, it's a produce of time and etc. But the constitution, yes, there is normally, you have to have a design, and probably you know about constitutional design, you have ideas, you know what generally what you want, and then after you have to negotiate that with the political forces. So so if I understand you have to be careful about the different fields of study. It's not always, you know, transposable. I think Tushnet does in his piece a lot of, you know, references to other works, but they are not in law, you know, in anthropology and also in literature. And it's a bit, sometimes it's a bit tricky. Yeah.
Thank you. The last question is, it's from Annie Daniel. And how far do you have to consider political systems, federalism, so the political structure, when deciding on what country's legal system to compare? Does it always depend on the specific research question, or are there other more general points to consider?
Well, I think it's actually both. It's what you need to do, I think. It always depends on your own specific topic, okay? But it doesn't prevent you from, if you talk about federalism, for example, okay, to refer to general works about federalism, general works on the theory of federalism. So you have this background, and then you can study what is relevant to your point about federalism, because I doubt that, you know, on a specific point of federalism, there would be, you know, a lot of works, but there are, you know, scholars who, I'm thinking about Chris McCrudden, for example, who works on federalism, okay? And an interesting example as well is Belgium, for example. The Belgian constitutional system is very interesting in that sense because it's a federal state, although it's a very small state. And it's a federal state since only 1993. But it also, you know, it's also a state which is organized like France. So you have regions and you have communities, etc. So it's the double layers of things. So you have to know about the theory behind federalism, but then adapt the theory to your own purpose, to your own thing. So I think it would be the level of knowledge of the political system is important. Yes, you have to, but you have to know about the theory as well behind it. Yeah.
So I think we have reached the time, and no more questions. I appreciate this insightful answers and the speech. Thank you, Professor Paris. Thank you for your time. Thank you for the attendees for their time.
Thank you very much, Faris. I was delighted to be with you today and to share all these interesting questions and thoughts. Yeah.